But at the outset, my lord, I must say that it is not the contention of the central government. It is not A versus B. My lord, some of the states have filed their reply that state opposing the reference. There is neither supporting or opposing the reference. Questions are put. So I'm answering those questions that this is our interpretation. My interpretation is not that it is an absolute and unbridled right of the governor to sit endlessly for no reason on a bill. That's not the high-pitch argument which the central government would like to raise. B, the governor does have 4 options, my lord, to which I'll not labor much. Because, my lord, after having learned, my lord, heard, my lord, the illuminating arguments of Mr. Sibal, Mr. Subramaniam, Mr. Datar, I've also gone through the note of Dr. Singhvi, etc. Lord, substantially, Lord, all of us have covered, except, my lord, points where they somehow missed, my lord, some of the judgments, etc. I'm not going to repeat any of the judgments because I know I am at the stage of rejoinder. I have filed my written.
Sangana Rao said there is no question of rejoinder.
Anyway.
You are saying this is only a reference.
I'll not enter into that debate, my lord. It's unnecessary, my lord.
Technically, he's right. Technically, he's right. Technically, he's right. But I think, my lord, because the issues are complex, my lord, we have no.
Lord, it's not a question of, my lord, my being a petitioner,
yes,
they
exactly.
being a respondent, and therefore I am giving a rejoinder. It is a question of assisting the court that this is the view of the central government, this is the view of some state governments, these are the views of this another state governments, and if they have expressed certain views, their interpretations, Lord, then I am just reacting or responding to their, my lord. It cannot be taken, my lord, in that strict jacket rejoinder, reply, rejoinder argument.
Because it's not a list, my lord. Because it's not a list.
It's not a list, my lord.
Therefore, there is no rejoinder, but I think we should not object if the solicitor wants to.
It's only an opinion.
No, my lord.
Not binding on anyone.
My lord, I would not reduce.
It is a report.
We have had the perspective of 2 extreme views taken and argued by the 2 sides.
Your lordships are
The
right.
balance, we will have to bring it.
Yes.
I think we have seen the extreme views from both sides.
Correct. My lords, your lordships may, my lord, find.
It's a very enormous task that we have.
Your lordships, my lord, therefore.
And the task of 18,000 pages.
That's, my lord, that's a Herculean task.
Unfortunately, there is no summer vacation in between now and 24th November.
Yes, my lord, there is none. My lord, and your lordships.
The attorney has contributed only very little part of it. I said, I have contributed only very little part of it.
Yes.
Pages have gone up to 25,000, not 18,000. 25,000. Volume 5.62.
But, my lord, to be fair to everyone, we have not, none of us, my lord, have cited all judgments which are placed on record. My lord, possibly they are placed on record in case, my lord, it is required to be cited.
The tool of constitutional silence.
Yeah, yes, my lord. My lord, volume 1.9 may be taken, my lord, and I can assure your lordships, I am not going to read everything. I'll skip most of the paragraphs, but they are my submissions, my lord.
Another volume, no?
Yeah, my lord, it's a
Rejoinder volume.
rejoinder volume, my lord, a response, or my lord, I have termed it as a rejoinder.
Rejoinder submissions on behalf of the solicitor. Got it.
So this is the central government's interpretation, I'll put it that way, to the interpretation canvassed by some of the state governments. My lord, and I would, my lord, respectfully say, I would not reduce the august jurisdiction of this honorable court, that is advisory jurisdiction, of a mere giving a report which is not binding, which is not worth a piece of paper. Lord, no. Your lordship's opinion, Lord, is a law declared, and I'll make that good. And your lordships can even declare, I'm repeating, your lordships can even declare that this particular judgment or the view expressed does not lay down the correct law. Your lordships can even overrule that. It's not just, my lord, a communication or conversation between the President of India and the Supreme Court of India. My lord, the President of India has, my lord, you may my lord, has sought your lordship's opinion, and your lordships are interpreting the constitution while giving that opinion. My lord, kindly come to page 746. My lord, these are the broad propositions, my lord, which are argued, and I'll deal with it, my lord, without repeating anything, my lord. And if your lordship finds any repetition, your lordships may, my lord, kindly tell me. I'll proceed further to the next point. My lord, the argument number one: governors have no power to withhold a bill in any circumstances whatsoever. Number two, the governor has no discretion in any circumstances whatsoever under Article 200, meaning thereby the moment the bill is presented before him, in every situation he is supposed to act in aid and advice of the Council of Ministers, meaning thereby, if I put it, paraphrase it in my own way, they have not argued in that way, that he is a postman with only two difference, that his car has a beacon and he has a bigger house. That's, my lord, constitutionally a flawed argument. Third, the governor therefore is not to apply his mind to the process. So this was an argument made. The action of the governor is judicially reviewable to the fullest extent. My lord, I have certain constitutional submissions to make, my lord, before your lordship, my lord, which I have already made, but some additional submissions, my lord, which I make, that it is not amenable to judicial review. Even if it is amenable to judicial review, it is not justiciable. And I'll give the reasons, my lord, in a nutshell. The governor is answerable like any other executive authority making any other routine administrative executive decision. My lord, this is again, my lord, in my respectful submission, constitutionally not correct, because as I'll show, my lord, from the scheme of the constitution, the legislative process starts from a particular article, my lord. Thereafter, it comes to introduction of the bill. Thereafter, how the bill travels, and it ends, the legislative process ends with the assent of the governor. Your lordships are aware, the governor is a part, he is a component of the legislative assembly, but he has no right to vote. He cannot preside over the meeting. But nonetheless, he is a part of the legislature because the legislative process commencing from introduction of bill culminates into the final step of legislative process under Article 200, when he gives his assent. And the last, the governor must act within a set time frame as provided for by the court, absent any constitutional provision. My lord, kindly turn the page over. My lord, I have, my lord, already narrated, but I am emphasizing, my lord, this oath of office, my lord, because your lordships are considering the powers, functions, duties, responsibilities, etc. of the governor. And there is one judgment which is not so far cited, for which, as a prelude, I would like, my lord, your lordships to see which oath the governor and the president takes, which is, my lord, these are the only two functionaries for which, my lord, this specially defined oath is, my lord, contemplated in the Constitution, Article 159. I so and so do swear in the name of God that I'll faithfully execute the solemn affirm office of governor of so and so, will to the best of my ability preserve, protect, and defend the Constitution and the law. Lord, my first respectful submission is that there are certain implied discretions, which I will come to, my lord, little later. And one of the implied discretion, my lord, would flow from his duty to preserve, protect, and defend the Constitution. Lord, now, please, my lord, come to Article 167, which is quoted at page 747. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for the legislation, to furnish such information relating to the administrations of the affairs of the state and proposals for legislation as the governor may call for. He can even ask this, how this particular government is functioning. And I'll, my lord, show Supreme Court, as your lordships have said, why this is the power conferred upon you. See, if the governor so requires to submit for the consideration of Council of Ministers any matter on which a decision has been taken by the minister, but which has not been considered by the council. He can say that such a decision of this magnitude, decision affecting the entire state or decision affecting the economy of the state could not have been decided by one individual minister, place it before the cabinet. Lord, these are the responsibilities of the Honorable Chief Minister of the state. Lord, now in this context, please read the Constitution Bench judgment, which is so far not read, my lord. That is case of BP Singhal versus Union of India. Page 748, my lords. Lord, your lordships may see para 35 of this judgment. My lord, last line, which nothing, my lord, says much, it says the constitutional position. He thus occupies a high constitutional office with important constitutional functions and duties. Now, please see further. In state of Rajasthan versus Union of India, my lord, please mark, this is a 7-judge bench judgment. A constitution bench of this court described the proposition of the governor thus: the position of the governor as the constitutional head of a state, as a unit of the Indian Union, as well as the formal channel of communication between Union and the state government, who is appointed under Article 155 of the Constitution by the President by warrant under his hand and seal, was also touched in the course of arguments before us. On the one hand, as the constitutional head of the state, he is ordinarily bound. Please mark, my lord. The argument was that he is always bound. 7 judges bench says ordinarily bound by reason of a constitutional convention by the advice of his council of ministers conveyed to him through the chief minister, barring very exceptional circumstances, among which may be pointed out by my learned brother Justice Bhagwati and Justice Krishna Iyer in Samser Singh case, a situation in which an appeal to the electorate by a dissolution is called for. On the other hand, as the defender of the Constitution, look, this is why I read the oath he takes, as a defender of the Constitution and the law and the watchdog of interest of the whole country and well-being of the people of his state in particular, the governor is vested with certain discretionary powers in exercise of which he can act independently. One of his independent functions is making of report to the union government, on the strength of which the presidential power under Article 356 of the Constitution could be exercised. Insofar as he acts in the larger interest of the people appointed by the president to defend the Constitution and the law, he acts as an observer on behalf of the union and has to keep a watch on how the administrative machinery and each organ of the constitutional government is working in the state. Unless he keeps such a watch over all governmental activities and the state of public feelings about them, he cannot satisfactorily discharge his function of making the report which may form the basis of the presidential satisfaction under Article 356(1). My lord, here the 7-judge bench reads the implied discretion that under certain circumstances, as a watchdog, as a representative of the union, as a representative of the president, he will have to have certain discretionary powers, and one of the illustrative power is Article 356. Lord, further, Lord, this BP Singhal cites state of Karnataka. Lord, another 7-judge bench judgment. Lord. The governor of a state is appointed by the president and holds office. By state administration is carried on by him, etc., etc. My lord, your lordships may, my lord, kindly see there are, my lord, your lordships can skip 38. 38. Another constitution, my lord, this is all quoted in BP Singhal. Another constitution bench of this court in Hargovind Pant versus Raghukul Tilak. My lord, please see, my lord, only the highlighted part. My lord, I have quoted everything so that I am not accused of selectively quoting, but what is relevant for the present purpose, would be, my lord, in my submission, the highlighted part. The governor is the head of the state and holds a high constitutional office which carries with it important constitutional functions and duties, and he cannot, therefore, even by stretching the language to a breaking point, be regarded as an employee or servant of the government of India. My lord, not in these words, but my lord, Dr. Singhvi virtually said that he is just, my lord, a nobody who is sitting there on behalf of Union of India. He is not amenable to the direction of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. He is an independent constitutional office which is not subject to the control of government of India. He is constitutionally the head of the state in whom is vested the executive power of the state and without whose assent there can be no legislation in exercise of the legislative power of the state. Grant of assent is exercise of legislative power of the state. And this would be relevant, my lord, when your lordship are pleased to examine the justiciability and locus of filing writ petitions which is conferred by, my lord, this honorable court. There can therefore be no doubt that the office of the governor is not an employment under the government of India, etc. 5 is important. It is impossible to hold that governor is under the control of the government of India. His office is not subordinate or subservient to the government of India. He is not amenable to the directions of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. Then, my lord, Rameshwar Prasad is quoted. My lord, this is again, my lord, constitution bench, but I'm skipping para 39 and directly coming to para 40. My lord, this would be, my lord, assisting your lordships, my lord, immensely. It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. My lord, I am not disputing. Normally, ordinarily, the governor will have to act in aid and advice of the council of ministers. As, my lord, stated by Mr. Singhvi, he is not a super chief minister, neither expected to be super chief minister. That's not the role envisaged under the constitution. The first is that of a constitutional head of the state bound by the aid and advice of his ministers. The second is to function as a vital link between the union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government.
That is during the period of emergency.
No, my lords. My lord, I'll just give an example. I was going to give an example, my lord. A very, very good example. If we take away, if your lordships, my lord, read that